Hello, welcome back to Move Ahead with Dalia. On today's show, I have Robert Loncar. He is an attorney and founder of Loncar Law. Bobby, thank you for being here today.
Thank you for having me.
Yes, of course. I appreciate it. You are a very busy attorney. So let's get started. I wanted to mention that we're going to be talking about the eviction process. But before we do that, I'd love for you to share some information about your law practice, your staff, and your office.
All right, here goes. Let's see. I started up this office in September of 2011, so we're on year 12 at the moment. Yeah, so
Yes.
September we just celebrated our 12th year, and
Nice.
we've grown considerably since it was just me in a small office in South Chicago. Currently, we're fully staffed. We have one associate attorney at the moment. We're down one at the moment as well, but we hope to get that seat filled. As far as the staff, we're fully staffed to be able to handle everything real estate related, from your real estate closings to the evictions. Sometimes property owners run into issues with the city, and we have to fix those. So
Okay.
we have staff available for that as well. We're also located on the southeast side of Chicago, which is where we started.
Okay.
And we also have a loop office. So as far as accessibility for the clients, you can come see us with ease regardless of where you're at. The loop office is centrally located for the greater Chicagoland area. A lot of our south side clients and even some of our north side clients who don't want to pay for parking tend to like to go to the southeast side
Yes.
office. It's also conveniently located for Northwest Indiana, where we have a lot of clients who invest in Illinois and have properties in Illinois, etc.
Wonderful.
And actually, I'm licensed in Indiana as well. Would you know it?
Oh, that's good to know. Awesome. So you have how many people in your staff?
On the attorney side, as I mentioned, we're down one right now, so it's currently two, including myself.
Okay.
On the administrative assistant side, paralegals, law clerks, etc., I'm counting 1, 2, 3, 4, 5.
Wow.
So it's a total of about 7 or 8 of us in the office at any given point.
Yes, and you handle a lot of laws. So tell me a little bit more about what it is that you practice at your office.
Yeah, it's a lot of practice areas, but it's mostly geared towards real estate.
Okay.
So we got the buyers and the sellers for the real estate closings. We got the
Wonderful.
evictions for the landlords. We got the building violations with the city of Chicago for the most part, but the suburban land property owners run into stuff on occasion as well.
Yeah.
We handle a few litigation files here and there as well.
Okay.
And even those tend to be geared towards real estate. We don't handle any personal injury or bankruptcy or anything like that, but we're generally able to point people in the right direction if they call for those matters.
Yeah. Okay. Awesome. Can you tell us a little bit about your background and your education?
Let's see. I grew up on the southeast side of Chicago where I still live. My wife grew up down there as well, and now we're raising our children there.
Oh, nice.
We met in high school, actually, Bishop
Aw.
Noll Institute, Northwest Indiana. And after high school, I went on to college. I went to the University of Illinois. A couple of years at the, what they call the one in Chicago, the Circle campus.
Yes.
Now known as UIC mostly, right? Then I transferred down to the Champaign-Urbana campus. After I graduated law school, I took a year off, did some cooking at Buffalo Wild Wings. Worked as a line cook for about a year. I thought that was an interesting
Restaurant work
experience.
is very hard.
And I know it firsthand, believe
Yes.
me. You get these people sometimes complaining about their orders wrong because somebody, God forbid, put mayonnaise on it. It's all right, we can fix it. You don't have to get all up. So I took a year off and I did that for a while. And then I started law school at the John Marshall Law School, which is now known as UIC School of Law. Graduated in 2010. I worked for a firm for about less than a year before I decided to put up my own shingle. And that's where Loncar Law started.
And you started it on the south side, as you mentioned.
Correct.
Okay.
I thought just a lifestyle, it's a matter of lifestyle, right? Why do we do what we do? We're all looking for a particular lifestyle. And I remember when I was working for a firm for about a year after law school, that commute to downtown from where I live was not ideal. So my first office when I went out on my own was at 55th and Everett in Hyde Park, halfway from where I live to the Loop. And I remember thinking, man, it's so much nicer to travel to this office than all the way into the Loop.
Yes.
I was there for about a year when I decided to move it to 92nd and Commercial, which was even closer. I had like a 5-minute commute to work. You couldn't beat that.
Oh, nice.
So that's where it
Okay.
started. Lifestyle, having a presence in the community.
Yeah.
And at some point, we grew to a point where we felt that having a Loop presence was important, not just for business reasons, but also for convenience to people in the greater Chicagoland area. Where we're at on the southeast side, it can be perceived to be a little isolated.
Yeah.
And having that loop presence really helps us reach the greater Chicagoland area.
Yes, absolutely. And speaking of community, I know that we met through Spanish Coalition for Housing, the nonprofit organization, and they have one on the north side, and I believe they have a couple on the south side.
That's right.
Yeah, so we met, you were giving a presentation specifically about the eviction process, and I attended it to learn about it, and of course to support Spanish Coalition. And it was an amazing presentation. I have to tell you, I still have your presentation sheets, and I reference it because you gave a lot of great information. So let's talk a little bit about that. Of course, no one wants to go through the eviction process. Landlords don't want to file, and tenants don't want to see that they're being evicted.
Correct.
But unfortunately, the reality is that sometimes things get out of control, and the landlord has no choice and has to file. I know that there's an option for homeowners and landlords to file on their own, but there is, of course, going through an attorney that has experience in filing would probably be a more favorable outcome, I would say, for the landlord. Could you talk about that?
Yeah, well, if you're on the plaintiff's side on an eviction, the outcome is always the tenant needs to leave. Unless, of course, it's really about the money. Sometimes there's other issues at play. Sometimes there's violent behavior going on at the unit. Sometimes there's nuisance problems, people throwing trash off the balconies. None of the neighbors want to see that. But when it really is just about the money, we can always work out some kind of a payment plan. So sometimes the end result in those does not involve the tenant having to leave.
Right.
But where I think our services come into play is getting to achieve that result with the least friction. Okay. Because what landlords have to go through, and it's the law, right? We have to follow the law. We lawyers don't make the law, but we understand the law, and we know how to navigate the system and get from point A to point B all the way through to the end. And it can be quite complicated for the layperson, and even for attorneys who don't practice in this area. Mm-hmm. And what we have at my office is an assembly line, so to speak, where we have a lot of these evictions just kind of moving through the process. Right. And in doing that, we're able to keep the rates relatively affordable for the landlord. Okay. We're able to work out, to an extent, flat fee representation, et cetera, et cetera. And what you have when you have, what happens when somebody tries to do it themselves and they don't really know what they're doing, is it causes unnecessary delay. Yes. The problem is that even if you get it through the system as quickly as possible, you're looking at a good 8 months from the time that first notice is served to the time an eviction order is entered. Now you got to wait for the sheriff to come out. And whatever you can do to shorten that time period, or at least prevent any unnecessary delay, it needs to be done. Yeah. Okay. Well, the time frame sounds painful. Yes. I can only imagine. I was a landlord for a brief part of my life, and I did run into, unfortunately, tenants that weren't paying consistently or didn't pay at all. And luckily, I did not evict. I didn't have to go through the eviction. I could have, but I did everything possible not to. But again, like I said, there are unfortunate situations where the landlord just doesn't have a choice. I know that there is also, and I wanted to mention, because I'm not promoting evictions, I feel that, of course, if there is a way to avoid them, that the landlord and the tenant should. But I also want to mention that there is an organization through Cook County, the Cook County Legal Aid, that does offer free help to landlords and tenants. And I don't know anything about them except I know their website. So I wanted to share that so that people who are interested in getting information for free legal help, that they can look into it. The website is cookcountylegalaid.org, O-R-G. So keep that in mind. But let's talk a little bit more about the process. The breakdown you gave of your presentation was incredible. Like I said, I go through it and take a look at it because it really gives a really eye-opening idea of the process. Can you share a little bit more about
When someone reaches out to you and they know they have to evict someone, what happens?
So first we need to find out what the basis of the eviction is for. Is it for non-payment? Is it a no-cause eviction? And I always put no cause in quotes
Yes,
because
I saw that.
there's no such thing as a no-cause eviction. There's always a reason. But the problem sometimes is that the actual reason is difficult to prove. So for example, drug and gang activity.
Okay.
Sometimes people in the surrounding units and the neighbors and the property managers are very well aware that it's happening, but you have to prove it in order to proceed with an eviction based on any kind of violations of the law. And if that was, people need to understand that proving things in court while following the rules of evidence is incredibly difficult. People go to law school and learn about the stuff, et cetera, et cetera.
Yeah.
You can't just go in there and say they're dealing drugs in there. I know this because my neighbor told me, or something like that.
Right.
So the way to really get rid of tenants who are engaging in that kind of activity is to go for a no-cause eviction. So that would be a 60 or 120-day notice, depending on the circumstances, or if it's no payment of rent, it would be a 5-day notice. But that's the first step, is to ascertain what the purpose of what the basis for the eviction is. Will tell you what kind of notice you have to serve. That's
I see.
Step one. And I always divide the eviction process into these steps or stages, right? And there's 5 altogether that I've identified. And at step 1 is really just serving that notice. I hereby demand possession. Here you go. And this is the reason.
Okay.
Right?
And it has to be done physically.
Yes, personal service. You got to serve. I've heard people say I posted it on the door. I say you can't do that. They say some other lawyer said I can. Well, I might say, well, then go with that lawyer. But I kind of think we know what we're talking about here. There's a limited number of circumstances where posting can be done. However, it's incredibly rare that this is actually the facts on the ground.
Okay.
And we're always very hesitant to tell landlords like that, yes, you can do it this way. In either event, though, regardless of which notice is served how, once proper service is effectuated, now we move into step 2. Now it's time to file the eviction. So you go to the court and you file, well, or from your computer, everything's done by e-filing now, right?
Yes.
So you file the summons and the complaint, and now you're official. You're in stage 2. You have this case pending, and now the next step is we have to serve the defendant or the tenants. And I have people tell me all the time, but I already served them. No, that was the 5-day notice or the 60-day notice or whatever it happened to be. Now we have to serve them an additional notice saying that they're being sued.
Oh.
And that's where you can run into some delays, because in Cook County, for example, you cannot serve someone with a special process server until the process server is appointed by the court.
Okay.
You can't do that until you've first been able to demonstrate that the Cook County Sheriff has been unable to serve them. So we got to get it to the sheriff first. The sheriff, I've never actually done the numbers, but if I had to eyeball it, I'd say they have a success rate of about 40% in serving defendants on these. So the landlords get really frustrated because we file the case. We have to wait 5 weeks before we're even in court, only to find out the sheriff didn't serve them. Now we appoint a special process server.
Okay.
Now you're looking at another 3 to 4,
So
sometimes 5 weeks.
you can't get a special, what did you call it?
Special process server.
A process server until you go to court physically.
Or via Zoom.
Okay.
But in either event, correct. In Cook County, and it's unique to Cook County and other counties with a population of 3 million or more, and I think it's only Cook County, to be honest. A special process server needs to be appointed by the court, and the court won't appoint the special process server until they see that the sheriff came back unsuccessful.
I see.
Outside of Cook County, you can get it straight to the special process server. It's really just a Cook County thing.
No kidding.
But
interesting.
More time is going by, and at some point we will get service, even if it's by posting down the line. Yeah. But before we are able to serve by posting, we have to demonstrate to the court that the special process server made a reasonably sufficient number of attempts in order to go posting, and the clients are pulling their hair out. They blame us, we're not trying hard enough, or whatever the case might be.
But you already know that this takes time.
Exactly. We know exactly how the system plays out.
Yes.
And I told one client recently that what separates us from some of the family law attorneys, and no offense to them, but you always got that plug, right? That push. Hey, hire me. I want to make sure you get the house, the money. Your spouse isn't entitled to anything. Several years down the line, hey, listen, we need to talk. I, on the other hand, tell the clients they're essentially screwed right now. This is going to take a long time. It's going to suck.
Yeah.
And there's nothing I can do to make it unpainful But what we can say is that we know the process, and we're going to get it through the system as fluidly as possible, given what we have to go up against.
Yeah, I mean, it's setting the expectation from the beginning, right?
Exactly.
That's the only way that they won't attack you verbally, hopefully only. But yeah, it's setting the expectation.
Yeah, if I tell them on day one, I'll get them out quick.
Yeah,
There's nothing's happening quickly in that system.
No, absolutely. So that was stage 2 or step 2, right?
Step 2, right? So we got to serve them. Once they're served, and by the way, if at any point the tenants vacate, which happens sometimes,
Yeah.
you're done. We've achieved our goal.
Yeah.
So, but until they vacate, we're going through this process. You got step 2, now they're served. We jump into step 3. What does that look like? Well, now, if you're dealing Cook County, specifically Chicago, because Cook County's got multiple suburban districts,
Okay.
and they each handle this step 3 a little differently.
Okay.
And most of this stuff goes in Chicago. And I think most of the people are watching are likely in Chicago.
Yes.
And in Chicago, at the Dalia Center, this case is going to be in 1302, which basically acts as they used to call it like a triage room, where all the cases that their first time ups in service are here. Defendant's either going to show up or not show up. If the defendant shows up, it's going to be sent to ERP. It's going to be kicked out 4 weeks for ERP status. And I've had clients come to me. They'll log into Zoom sometimes and watch, and they're more than welcome to. They have every right to be there. But then they call our offices and say, why did the attorney let them continue 4 weeks for ERP status? Well, he just let them do it. But the fact is, that's the rule. There's a rule that says it's going to be kicked out 4 weeks for ERP status.
Okay.
There's nothing anyone can do about that.
And when you say defendant, you mean the tenant,
Correct.
right? Okay.
Sometimes I do everything to break it down, kind of like
Yeah,
people
yeah.
talking. Every once in a while, the legalese kind of
Oh
gets
no,
in
my
there.
brain's like, which is the defendant? Defendant.
I get it. Yeah, the tenant. And if the tenant does not show up the first time, however,
Okay.
they'll kick it out 2 weeks for status prove up. Our office is to notify the tenant of the new date.
Okay.
If we come back that second time, 2 weeks later, and the tenant still doesn't show up, we can usually get our eviction order entered on that day.
Oh.
However, if they do show up, now it goes to ERP, but not for the entire 4 weeks, but just 2 weeks, because the court realizes that the one side benefits from not showing up the first time if they get another 4 weeks from the second time.
Well, at least, right? There's that.
At least as much. In either event, if that eviction order is entered and the tenants didn't show up, we're on to move to the final stage, actually, because we got our eviction order. Remember, if the tenants don't vacate, that's what you're looking for, is the eviction order.
Right.
However, if the tenants do show up and it goes to ERP, and then we should come back on that ERP status date.
And ERP is?
It stands for Early Resolution Program. It's a post-COVID program that came into being towards the end of the moratorium, as the moratorium was slowly being lifted, and the evictions were slowly coming back in. And I think it's a Cook County program. Outside of Cook County, there are other programs that are similar, but it's Early Resolution Program. Its stated goal is to help resolve eviction matters in a way that does not result in the tenant being evicted, which is, I think, a well-intentioned motive, but it's really just about being able to work something out. And unfortunately, in practice, it's turned into something where it's really just a 4-week delay. Pre-COVID, I was able to, without ERP, settle most of these evictions in a way that did not result in eviction.
Oh.
You had a vacate date, you had a pay and stay arrangement, some kind of payment plan. But as things stand right now, it goes 4 weeks through this process. Sometimes we'll be contacted by the program to see if we want to work something out. Other times we don't hear anything, and we just have to wait till we get to that ERP status. And more often than not, by the time we get here, case is not settled. They're going to assign it to a trial room.
Okay.
And there's stage
4?
4.
Okay.
And stage 4 is almost where the system meets up with how things used to be. Now it goes to a trial room on the 14th floor at the Dalia Center. We have an intake date. Now let's keep in mind these time periods, right? You had, from day one, you served that notice. And then you had the time, either 5 or 60 or 120 days until the notice expires. Now you file your eviction action and you have to get service. You could be talking a good 7-8 weeks in that stage 2. Stage 3 took 4 weeks. We know that. And now we're entering into stage 4. How long does that take? Now you're looking at another maybe 2-3 weeks from that ERP status date that you're now going into the trial room for an intake. You're not even going to get anything done on that day. You're going to have an intake.
What does that mean, an intake?
So basically, it means that for this case in particular, it's its first time up in this new courtroom.
Oh, okay.
And the judge this will give us an opportunity to see if we can work something out. So they can put us, if the defendant appears, they can put us into a breakout room and we can see if we can work something out. Working something out is always good. It provides certainty. If we can't work anything out, it's going to be set for trial. And that trial date's going to be 2 to 5 weeks out, depending on which room you're in and depending on what the court schedule looks like. So the question becomes, if the defendant doesn't appear at the trial room intake, some judges will enter an eviction order, others will continue for prove-up. There's so many different forks in the road.
Yes, that's how I'm envisioning it. I'm like, okay, now you got here, now there's this way or that way. So it just seems like there's so many. Well, that's why we need an attorney to help us with it.
We're very familiar with the process, and it's also why when I give these presentations for organizations like the Spanish Coalition for Housing, I've done them for CHA as well, and CIC, through some of their landlord training programs, and it's really difficult to articulate how this process is navigated because there's so many forks in the road. It's impossible to go through each and every one, and sometimes somebody will call us after one of these things and they want to retain us for an eviction or maybe step in on one that they've filed themselves, but they got a little botched at some point, you know, and then something comes up that I maybe didn't mention at the presentation because it comes up so rarely. But the fact is, it's impossible to go through every single possibility.
Scenario, right? There's too many scenarios. And it's like with me in real estate, every client has a different, they may have the same goal of buying a home or selling a home, but their scenarios are different. What they're experiencing, what their situations are. So yes, it all depends on what's going on with the landlord and the tenant.
Yeah, don't you love it when the buyers get their inspection done? They get that report and they say, "So what should we do about this?" And it's like, I don't know, client. What do you want to do about it? And every buyer is going to be different. Some of them are the fixer-up types, and they actually expected this to come up.
Yes.
Others say, hey, this means that we can get some credit, right, or something. And it really just is in the eye of the beholder. And
yes. Well, and that's where your realtor should be guiding the buyer as well.
Exactly. And on the seller side also, if we kill the deal over this, what's the likelihood we're going to get somebody who doesn't raise this as an issue?
Exactly.
That's why we're professionals.
I bring that up all the time. I had a scenario like that recently, and I told the listing agent, it's going to come up again, so can we settle it?
Exactly.
Yeah. It's about settling the situation so that it doesn't snowball.
Yeah.
Right?
The worst thing you can do is throw fuel on a fire and just let it get out of control. Yeah. You want to take things and bring the situation under control, get everybody to think rationally and calmly. And once everybody's being reasonable, there's always something that can be worked out. And I mean, there's deal killers out there, don't get me wrong, and some of them aren't that unreasonable.
Right.
But for the most part, things can be fixed.
Most of the time, I agree with you on that. So then, so is the stage 5 when the court decides the eviction is allowed? What is that term?
So let's say we go through stage 4, and I had mentioned we have a trial room intake. If we can't settle now, we're going to set it for trial. Then we have our trial. This is our opportunity to demonstrate. And by the way, now all trials are in person. It's official. There was some back and forth on it. They were held via Zoom for a while, but now all trials are in person. And sometimes you tell people, hey, listen, if we don't settle this, you're going to have to drive into downtown for a trial. Because we get it.
That makes them nervous.
It's inconvenient.
Yes.
You have to get in there. You got to pay for parking.
Yes.
You have to spend probably an entire morning at the Daily Center. But what I'll need at trial is 2 people. And sometimes they're one and the same. So I'm going to need one person who can testify with firsthand knowledge that I manage this property. I'm familiar with this defendant here. I know what they paid and what they did not pay. I know that they owe this much, etc. They were served a 5-day notice, and now they owe this much. They're still in there. The next guy's got to tell me I served this 5-day notice. And more often than not, it's one and the same person. But sometimes you're going to have a property manager and a separate maintenance person of some sort who actually served it, etc.
So the witness or the actual person serving it, right?
Correct.
Okay.
Because what will come up, we have an affidavit on file saying that the defendants have been served. But if they come into court saying they haven't been served, we need that live testimony to counteract that. And then it becomes a credibility issue. The judge will either believe this person or that person. And that's a bit of an art. But, for the most part, it rarely comes up. Sometimes people do come in and deny having received a notice, and then the judge has to decide whether he or she believes the person who served it or the person who's saying they weren't served. And I think we have a pretty good success rate on those.
Great.
I can't think of a single one of mine that have been dismissed on that basis. Because let's face it, my clients actually serve the notices. Right?
Well, and because you set the expectation in the beginning of the time frame, they stick through it, right? And at that in that process, it's like what we do in real estate is we are guiding our client from the beginning to the end.
Yeah. We're giving our advice.
Yeah.
I tell the clients I can't make your decision for you, but I can give you all of the information you need to make an informed decision.
Correct.
Once they have all the information, I found that people generally make the same decisions once they have the information in front of them, right?
Yeah.
So after the trial, and by the way, at trial, we still try to work it out. I'd rather work out an agreement with the tenant, something that either involves a vacate date or maybe sometimes a pay-in stay, get back caught up on your rent payments. It just depends on the individual circumstances. But if we're not able to work it out, we're going to have our trial. An eviction order will be entered, thus entering us into stage 5, where we can place that eviction order with the sheriff. And only, it has to be emphasized, only the Cook County Sheriff can perform an eviction.
Okay.
Very strict. And the eviction order is going to have this little sentence in it. It says tenants must vacate on or before, say, the 14th. If it was entered today, it would likely say September 21st. It's usually 7 days.
Okay.
Tenants must leave by September 21st. And sometimes the landlord thinks that means that after the 21st, they can go and change the locks, and that is not true.
No.
What that means is that after the 21st, now we can take it to the sheriff. And that's what I mean by stage 5. We're going to sit there and wait for the sheriff to come out. They're currently, I would estimate, at about 6 to 8 weeks from when we place it with them, which makes people want to pull their hair out. But it's actually
another month to month and a half.
Yeah.
Or no, a month to 2 months.
a month and a half to 2 months. Yeah.
Oof.
And that's actually pre-COVID levels right there.
Really?
Also, sometimes they don't make it out within that time. The eviction order expires after 120 days.
Oh, no.
And sometimes it actually takes them that long to sort it out. So now we got to go back in court, get an extension. And there's so many different things. But the best I could sum it up in, the limited time we have, that pretty much goes through the 5 stages of the eviction process.
Wow. Well, like I said, you did the presentation at the Spanish Coalition Landlord Workshop and really opened my eyes to so many of, I don't know how to explain it. It just was like the steps to get from A to B was incredible.
And keep in mind, a lot of these landlords, the vast majority of them are mom and pop landlords who have a couple of 2 flats at best. They forewent getting a job with a 401k and a pension and all that stuff. And instead, they just worked very hard, and they have this, what they consider their nest, right? And this is what they're going to retire off of. And I think there's too much out there that creates the perception that the landlord is some faceless corporation located in New York, and they're just greedy and they want to put all these people out in the streets. The fact is, the vast majority of them are hardworking people themselves who work very hard to have what they do have, and now this just kind of it hits them,
Yeah, it's very difficult, especially if the tenant damages the property. There's just a lot of unfortunate scenarios where even when the tenant is evicted, now the homeowner has to invest money in fixing what was damaged. So there's just a lot of expenses involved. So I know as a realtor that when my clients talk to me about buying properties that they want to invest in and they want to be landlords, one of the things that I suggest to them is to go through Spanish Coalition, who offers the Landlord Association. I think it's only like $50 a year, or maybe just the initial cost. And they help you with a lot of services as a landlord and teach you all the rules and regulations of the city and the county. So that's really, really important for homeowners that have tenants to understand, but not many people know that.
Yeah, and it's very important that anyone landlording is at least somewhat familiar with the CRLTO, the Chicago Residential Landlord and Tenant Ordinance, and other laws that regulate what they're doing, because there's a lot of laws in this ordinance, a lot of provisions that aren't necessarily common sense.
Yes.
And sometimes you can not be in strict compliance with this law and find yourself in with some liability. You're talking 2 times security deposit, all this stuff, and it's important that you're at least familiar with it. And that's why it's good that organizations like the Spanish Coalition for Housing are out there to familiarize these mom and pop landlords with what they're up against.
Correct. And another wonderful organization that does help from Belmont Cragen community is the Northwest Center CDC. I believe it's Community Development Corporation. They also have programs for landlord and tenants. So that's it's Northwest Center CDC and then Spanish Coalition for Housing, both nonprofits. They don't charge any fees and they help landlords and tenants with situations that come up. So
that's good.
I did want to mention your website again. It's loncarlaw.com. I love this website. I noticed that you have the forms, like the notices, that people can go online and download them, right?
Correct. But
so they could use them.
Yeah, but it's very important that we throw in there that the forms are just forms. And
Yes.
it's always good to consult with an attorney before using them. Some people use the forms all the time, but we've seen from some of my presentations that some of the forms can be a little nuanced, and it's important they're filled out in a particular way before serving, because you'd be surprised how many technical errors could invalidate a form.
Yes. I know one of them was if when you're putting the tenants' names on the form, you have to mention and all occupants.
Yeah, you really do want and all unknown occupants. I've been able to fix and get around situations where they weren't because we still had them listed as a defendant on the complaint. But I always tell people one of the things we do is about risk management, right? And we've talked about how long and expensive and frustrating this whole process is.
Yes.
So our goal is when we're going into it, we make it as solid as possible. We cross all the T's, we dot all the I's. So even when there's something such as a gray area where, is this really necessary? Does it really have to be in there? And, I don't know. It depends because there's room for argument. I would say maybe you're right. Maybe it doesn't need to be in there, whether it's all unknown occupants or something else that's some other language is in the form. But whose opinion matters more than mine is the judge who we're going to see 8 months from now. And I'd hate to be in a situation where I said that we can probably get away without this, and then it happens to be in front of a judge who disagrees with that 8 months later,
right,
and the case gets dismissed over a technicality. So we want to make sure that all these T's are crossed, I's are dotted. So when we get there, we know that our eviction order is going to be entered. And the goal is to not get there in the first place, right? We want to work something out. But in the event we can't, we want to make sure we're ready.
Okay. And you mentioned cost. What is like an average cost for eviction? And I know every scenario is very different, so you're not going to give a number. Is there a range?
If we're looking at ranges, a routine eviction can cost, and we're looking at attorney's fees and court costs here. Routine eviction costs about $1,200 to $1,500 and can easily reach about $2,000, depending on the circumstances. How many times did we have to send a special process server out there? How many court appearances did we have to make? Did we have to go all the way to stage 5 and give it to the sheriff? Or were we able to work this out nice and early? It depends on so many things. And not even, it would take another 90-minute presentation to go over a jury demand in itself.
I was going to ask you about that, but no, we're running out of time.
And that's where it can get very expensive. And I think the incentive to settle is increased because nobody wants to spend that kind of money on these things. They just want to settle.
Well, I've been at jury duty, and I've actually been a juror in cases, but not for a landlord-tenant situation. So I know there's that could get a little bit more challenging, right?
Challenging, and what happens. The way we're able to keep it affordable, relatively speaking, is that we have this assembly line where all of these files are exactly the same. And I know that the clients don't want to hear that because for each client, this is a terrible
they want to feel like
they want to know that this tenant really wronged me. He owes me a lot of money. Or they took the door off of the closet in the bedroom. And I totally get that. But the disconnect sometimes is that we hear it all the time on so many different files that the only way we can really keep moving these things efficiently is to treat them all the same and move them through the system. And what happens when you have something like a jury demand and you have a defendant or tenant who really wants to fight this, they take it out of that assembly line and they take this package and they bring it over here. And now an attorney needs to really look at this one file and spend a lot of time on this one file, whereas all the others just keep moving along efficiently. You know what I mean?
And that's what you want, efficiency. You want these things to move along so you can get to the final result.
Yes, and keep it affordable.
Yes.
And we don't want to have to put the time in and really send those bills, but once something gets moved over here, I mean, my people want to get paid too.
Of course, it involves costs, absolutely. Mm-hmm. Is there anything else that you want to mention that we haven't talked about on the show so that we can wrap it up?
No, I think we covered a lot of ground, and I appreciate you having given me the invitation to speak here. And if there's any other questions, don't hesitate to ever reach out. Absolutely.
Thank you so much for being here, Bobby. So again, the website is loncarlaw.com, and the main number is 773-734-5040, and you are Robert Loncar.
Yes, thank you very much.
Thank you. Thank you for listening.
Thank you.
Hey, thank you so much for listening today. If you're watching on YouTube, please subscribe so you can keep up with my latest episodes. You can find me on all social media platforms at Dalia the Realtor. To reach me directly, call me at 773-879-4855. I'll see you on the next episode. Make it a great day.